Judge has ruled qualified immunity has no basis in law. Federal judge out of Mississippi. The judge is correct. As a matter of fact, it's an argument we've made right here on Indisputable, that this is basically a legal doctrine or legal principle, not codified in statutory language. No federal law, no state law. This is case law, but is it? With millions watching and many people benefiting from this program called Indisputable, we just need 1% of the viewers to become a paid member so we can continue to bring this content to you. Now back to the show. All right, let's get into it. I'll put up the court full mass here. That is your United States District Court of the Southern District of Mississippi. A judge that sits in that building of the District Court of Southern District of Mississippi recently said no to qualified immunity to a detective who had falsely accused a Mississippi man of capital murder. And in doing so, also agreed with the plaintiff that qualified immunity itself is not based in law. The decision could reshape the landscape of civil rights litigation. The ruling handed down on May 20th could turn into a significant blow to the legal doctrine that has often shielded law enforcement and other government workers from lawsuits. The case centers around this man, Mr. Desmond Green. You see, Mr. Desmond Green never committed a crime. He was wrongfully accused and arrested based on the affidavit of a lying, drug-impaired jailhouse informant who was directly solicited and coerced by Jackson Police Detective Jacquelyn Thomas. The detective decided to guide the informant to identify Mr. Green from a photo lineup. That is according to the 62-page order issued by Judge Carlton W. Reeves, whom you see there. That is the judge. That led to Green spending nearly 2 years incarcerated inside of the Hinds County Detention Center, facility known for violence, rodent infestation, moldy food. That's according to the official order. At the time, Green lived in constant fear, often sleeping on the bare floor amidst constant yelling, fighting, and threats, Judge Reeves wrote. After the informant recanted the testimony, the charges against Green were dropped. Seeking justice for his wrongful prosecution and the harsh conditions of his confinement, Green filed a federal civil rights lawsuit against the detective, the city of Jackson, Hinds County, which operates the detention center. Now, let's go back to the genius of this lawsuit, okay? Typically, a lawsuit of this nature would argue that what the officer did does not qualify under the immunity principle. Remember, no statute, there's no law here. So typically the argument is what this individual did is so outside of the norm. It is so contrary to the scope of practice, meaning being a police officer, that he or she should not have the immunity. Remember, it's qualified immunity, which does mean there's a qualification for the immunity. Typically, that qualification is easy to reach based on the rulings for law enforcement. But there was another argument made in this particular case. The other argument was that not only did the officer do wrong, meaning violate the civil rights of this individual, the idea, the very notion of qualified immunity is not based in law. The federal judge ruled, yes, what the officer did was wrong. And yes, you are correct. Qualified immunity has no basis in law whatsoever. There's more. Green filed this lawsuit to seek justice for those two wrongs, his prosecution and conditions of confinement. He has sued the detective who obtained the false warrant against him, her employer, the city of Jackson, Mississippi, and the operator of the actual jail. This is what the judge placed inside of the written order. Green is now on the precipice of being wronged a third time, not by a rogue officer or jailer, he says, but by the law itself. Because the detective says the legal doctrine of qualified immunity requires the court to dismiss Green's claims against her. The ruling continued. Until this point, the decision was shaping up as a more or less standard denial of the government's claim that it was entitled to qualified immunity in the case, but that what Reeves wrote next struck at the heart of the doctrine itself. Judge Reeves said, quote, most plaintiffs in this situation argue that the officer that wronged them is not entitled to qualified immunity. Put up the judge again. And he has been outspoken before. This is not the first time he has stood up and told the truth outside of the normal bureaucracy of the federal bench. But this man, I want you to look at him as I read his words. He said most plaintiffs, because he can't rule based on what has not been filed. Most plaintiffs in this situation argue that the officer that wronged them is not entitled to qualified immunity. That is correct, meaning they tried to qualify or disqualify the immunity. Green does that. Unlike others, he has taken the next step and argued that qualified immunity itself is unlawful. He joins lawyers, professors, judges, and even the Supreme Court justices who have called for the doctrine's re-evaluation, if not its abolition. The court agrees with these calls for change. Congress's intent to protect citizens from government abuse cannot be overridden by judges who think they know better. As a doctrine that defies this basic principle, qualified immunity is an unconstitutional error. It is past time for the judiciary to correct this mistake. The doctrine of qualified immunity is a legal principle that protects government actors from being sued for their actions unless those actions have previously been ruled unconstitutional. The Supreme Court first carved out this protection in 1967 with this ruling in Pearson versus Ray, a case brought by a group of ministers who claimed that civil rights were violated by authorities in Jackson, Mississippi. Now, many times you simply have to look at the origin of a thing to understand the DNA of a thing. The DNA is its intended design. Now, can something go against its DNA? Yes. Nature versus nurture. But the DNA of this entire principle in law was rooted in one dynamic: racism. The principle of this legal doctrine was rooted in states initially, states in the South in particular, who wanted to make sure there was a provision of protection from officers who decided to bash in the heads of civil rights leaders and children who wanted to integrate. They wanted to make sure that those officers had no civil liability. They were able to keep their homes, pension, etc. There's more. Quote, qualified immunity was invented by the Supreme Court in 1967, Reeves wrote. In plain English, it means persons wronged by government agents cannot sue those agents unless the Supreme Court penned the Pearson case. The ministers argued that their 1961 wrongful arrest and imprisonment for simply entering a bus station was a violation of the 1871 KKK Act, a federal law enacted specifically to give Black citizens protection against police who would collude with white supremacists to violate the civil rights of African Americans. The High Court ruled in Pearson versus Ray that the Jackson police who arrested the clergyman for breach of peace were not liable because officers, quote, reasonably believed their actions were constitutional. We go back to what's called subjective standard versus objective standard. A police officer typically gets the allowance of a subjective standard, meaning it is whatever's in their heart and mind. While you and I, we have to live by a different set of rules, different set of laws. It's called objective standard, meaning a reasonable person, would they have concluded the same thing in that circumstance? However, cops, it doesn't matter. As long as they believed it, they typically get the immunity. Reeves, describing the twisted irony of the Pearson ruling, wrote, quote, "The justices took a law meant to protect freed people exercising their federal rights in southern states after the Civil War, then flipped its meaning. In creating qualified immunity, the High Court, 100 years after the war ended, southern trees bear strange fruit indeed. In a powerful conclusion, Reeves declared that qualified immunity has no basis in law and described it as an extra constitutional affront to other cherished values of our democracy. The ruling, in the unlikely event it is upheld on appeal, could lead to more accountability of law enforcement officers as an issue backed by several civil rights advocates and, frankly, attorneys. Clark Nelly, who is the senior vice president for legal studies at the Cato Institute, describing Reeves' ruling for Newsweek, said, quote, "Qualified immunity has become an extremely controversial legal issue because it creates this defense out of a whole cloth. Courts are not really supposed to make policy. They're supposed to rule on existing laws, but none exist here as it relates to qualified immunity. Critics argue that qualified immunity has allowed law enforcement to violate citizens' rights, especially those disenfranchised individuals, without facing any repercussions. Quote, "One of the biggest problems with qualified immunity is you cannot find it written in any federal law or statute." Attorneys Melvin Hall and Jeff Bell wrote in an op-ed published in Newsweek. Put up the picture of the young man who was wrongfully accused, wrongfully prosecuted, Mr. Desmond Green. Now, I want you to take a look at Mr. Desmond Green because Mr. Desmond Green is a hero. He is an American hero because of the way he filed this particular complaint due to the injustice that was visited upon him. Because of the way he has filed, he has now changed precedent. That man right there. So for those, and by the way, the majority of Republicans and Democrats agree that qualified immunity in its current form is much too protective of law enforcement. If you want to thank somebody for changing the policy in this country, thank that man. Because without his ruling, you do not have this precedent set by the United States Federal Court. Sir, we thank you, we salute you.